Yes, sorry for the delay.
For delivery of judgment, Criminal Appeal J 31/2021.
May it please your lordship. My lord, I beg to mention item number 9, your lordship. May it be adjourned till just immediate after vacation, your lordship. Item number 9, your lordship.
9.
9, lordship.
9. Which is a representative of the player made by the staff player says, "Complete the vacation."
June.
May it please your lordship, the item number 23, lordship. Lordship, confirmation, lordship, the petitioner, someone says the petitioner is expired, lordship. For instruction, lordship, after vacation, lordship.
Both sides are represented. So, and Abel also for the petitioner submits, has submitted that as per instructions received by me, the petitioner has expired, and therefore pays for some time to read instructions and take steps as the petitioner will be so, as and appropriate steps. Matter is adjourned today, placed on to
After we will,
they can give a fixed date.
May
Yes,
I please your lordship, may I for listing of the case, my lord. WC 656, 2018. Filing date, my lord, that is
take
3
it
1
today. We'll take
on
it
7
today.
1.
We will take it today at 4:30. We'll start the hearing. We'll take it up today. At 4:30, we'll start hearing. Extended time from 4 to 4:30, 4:30 to 5, we'll take up the matter. Give the listing. You're taking it up today.
I cannot take.
We don't know, you are making a mention, I am allowing it today. You want us to hear into these 2 days.
And also 2 cases, my lord.
That's why we are taking up both the matters today. You bring your file. Yes.
My lord. Item number 20, my lord. May I kindly pass over for the day.
20, okay. Same order. 2019, give a fixed date. Yes.
Obliged.
but I beg to mention for listing of motion, lordship. 2 more.
Motion gave it.
Lordship, 2 more. May it please your lordship. Lordship, I beg to mention item number 43, lordship.
43.
Yes, lordship.
Okay.
After vacation also.
You fixed date. I is there. Item 3.
28 1. Item 43.
Deeply obliged.
For motion, item 1 with 2. Connected with supplementary item 44.
May I please your lordship? Lordship, we file IA. Lordship, I file IA for substitution petition. So.
Heard Mr. D.K. Dey, learned counsel for the applicant, and so also for the respondents. Next. The applicant is the son. You're the son.
Lordship, elder son.
The elder brother of Bhanu Biswas, the petitioner in WBC 2596 of 2019. So the said writ petition was filed to assail the opinion dated 21/11/2018, passed by the learned member, Ordinance Tribunal number 2, Kamrup Boko, in BFT case number 1655 of 2016. Full stop. Next part. During the pendency of the said writ petition, the writ petitioner, namely,
Bhanu Biswas.
Bhanu Biswas, BHANU, Bhanu Biswas, died on 25/2019. Living. No, you are the elder son.
Two son, Lordship. He is the elder son, Lordship.
Oh, son, elder son.
He is the son.
Living behind the applicant. I think you'll have to withdraw this and file another application.
Lordship.
You are asking for substitution of one legal hair. You say that you have the father had two legal hairs. So if the other hair admits, you fall in the same trap.
Lordship, perhaps Lordship, younger son is already in the Lordship against him also.
He has already come.
Yes, Deepak Biswas.
Stop. Living behind two sons, out of which the applicant is the elder son. Full stop. The learned counsel for the applicant has submitted that the younger son is also a proceedee before the Foreigners Tribunal, and he has separately filed another writ petition being WPC 2590 of 2019 to assail the same opinion. Next. Accordingly, there is made for substituting the applicant as the representative of the deceased petitioner. Next. Having heard the learned standing counsel for the FTA border matters and NRC, application stands allowed. Full stop. The applicant namely so and so, it's allowed to be substituted on the death of Bhanu Biswas. Next one. This application stands allowed. And in the connected WBC 2596, pass an order, all sides are represented. By an order passed today in IA Civil 0137 of 2025. Substitution of the applicant in IA Civil 4137 of 2025 has been allowed. Next, the Learned Counsel for the petitioner shall file a amended cause title and hand it over to the AOJ civil rule pending, FT section, just to incorporate the same in the writ petition. So a copy of the amended cause title we also provided to the Learned Counsel for the appearing respondents. How much time?
After vacation, Lordship.
Within 8 January 2026. We're giving you extended time of 8 January.
Lordship.
Thereafter, the matter will be taken over. Acha, this item 54. 40.
1 and 2.
1 and 2. In item 2, you say list this matter with the connected WC to no, list this matter. We are passing separate products. List this matter as and when the WPC 2596 or 2015 was listed.
Obliged, Lordship.
Item 3,
Also, here the petitioner is on bail, your lordship. It's on bail. Bail.
Yeah, sir, come we fix it by hearing. Also, the represented pursuant to the earlier orders, the records of the tribunal is received. Court is inclined to issue rule returnable forthwith without requiring any press steps to be taken. Next, this is the matter for hearing in the first week of February 2026.
Obliged.
item 4,
Make to your lordship.
we are hearing again, but here, Mr. Kalita. No, I'm sorry, your name I forgot. And Kalita, yes. Mr. Kalita, here we need some information from you. Here there's an issue of draft copy of electoral roll. So what is a draft copy? You have to explain it to us. Can do it in the chamber. What is a draft electoral roll? In this case, the document exhibited was a draft electoral roll, which was not accepted. So please inform us, give us a clarity as to what is a draft electoral roll. You have to say, Ali, anyone, very fast.
There are few others on draft and exact copy of the quick list.
That's why we want to understand that.
They were never taking up like multiple piece of it.
No, that's okay, but we have to need clarity. Since we have the
Yes, yes.
two of us to decide the matter, we need some clarity. And Ms. Kataki, you also, please try to get the answers. Draft electoral roll and
Extract.
extract. We need to have some clarity on that. Not in this case, but as a general legal proposition. Not in this particular case, but general legal proposition. Same order. Here the name of the advocate is Mr. L.R. Mazumdar. Same.
That is pretty to exchange, but we get a big turn.
Same order. We are fixing it in the first week of April, February.
That's all. Oh, like,
Item 5 for motion.
Here, you were required to tell us about the caste certificate. It was made over to Mr. Payang.
it's not regarding.
Sort of.
Pass certificate.
So, this-
Buying of distributor. This is 19 at 19. पास सर्टिफिकेट में लिखी दी थी आते we'll get the instructions got it.
He is not coming regularly, Mr. G.P. Bhomik.
Yes, sir.
And in this case, he is the lead counsel.
Yes, sir.
So, you said they had appeared. Can you just tell me about this matter? Otherwise, it will be dismissed for non-prosecution.
It's not physically fit. It's not physically fit.
I understand, but until somebody tells us,
Yes, yes.
we can't issue a notice to the petitioner. The counsel on record may be offended.
Mm.
So that problem lies there. You can always communicate, but for us to communicate from the court is difficult.
Mr. J, we can
No, we are just
Communicate to
fixing it.
Mr. Day about this lordship.
Well,
ठीक है मैं तो item 1 2 को भी चले number 2 नो conflict. Lordship is issuing rule lordship.
This is, we are listing it after 2 weeks,
Yes,
after
sir.
opening, for this effect. None appears in call for the petitioner. Right, order dated 19/8/2019. The report was directed to be obtained from the All Assam Other Backward Classes Association regarding the caste certificate dated 5/11/2007 issued in favor of one Pakuli, Pakuli, Devnath. And the learned standing counsel for the border, FT matters and NRC codes. Requested to send the same to the deputy commissioner for doing the needful. Next month. Accordingly, in terms of order dated 19/8/2019, Mr. P. Sharma, Leonard, additional senior government advocate, and Mr. G. Sharma, Leonard, standing counsel for the FP border matters and NRC. They have obtained instructions. Next. Learned government advocate and the learned standing counsel for the border FP matters and NRC are committed to send the download copy of the orders. It's 19/8/2019, and order passed today to the deputy commissioner for MLT for doing the needful. List on 19 January, reopening date.
19 January is the caste certificate of. January.
Item 6.
Rama, in this case, the petitioner has not been able to connect, is no evidence at all. We'll take it up for hearing some other day. You get some breathing time. See, Mr. Elan Mazumdar, and counsel for the petitioner, and Spencer for the respondents. Next. pursuant to what is passed earlier, comma, the records of the tribunal is received. Accordingly, comma, the court is inclined to issue rule returnable forthwith without requiring any exception to be taken. Next, this is the matter for hearing in the week commencing to 2026.
Okay, yeah.
Item 7 for motion.
Please button up your vote. Button up your vote. Please button up your coat. We don't see you otherwise.
Start.
Button to my look.
Off.
Okay. Button to the right.
Yes. MDH Bhuya. H Bhuya.
Number Assyria 7. या पे क्या नाम है? मोहम्मद HP.
Item 8 for motion.
Please, your Lordship. Lordship, implement order at page 60. Six zero. In this case,
In this case, my lord, grandfathers, grandparents had casted vote in 1966. Yes, that's.
RT, Tanur. 3-0.
Next, the family members of the petitioner shall cause production of a certified copy of the order before the Superintendent of Police, Border, Sonitpur, Tejpur, bring the order to the notice of the said authority. List on, so and so.
Obliged.
Item 10,
नक्कीच गेलो असतो म्हणजे काली पास होता मतलब कितना टाइम नहीं
Just now. Okay. Pass.
Obliged.
item 11 for motion.
Made, is your lordship. Here impugn order lordship will find on page 22, 77 lordship. Mhm.
Mr. B. Chaudhary, and counsel for the petitioner, and so for the respondents. Opinion is at page 77, dated 26/4/2024, passed by so and so in FT second case number so and so, reference police number so and so. They were declaring petitioner to be a foreigner of post 25/3/1971 stream. Notice returnable on 30 January 2026. Extra copies within 2 days. Because to the following email address of the learned court, learned tribunal. The prayer for bail shall be considered. Visit of the tribunal's report. Next, in the meantime, if the petitioner, namely Kulsuma Khatun, alias Kulsum Nessa. In the opinion, there is different name. In the cost title, there is a different name.
Kulsuma Khatun and Kulsum Khatun lordship. Kulsuma lordship on page 20.
But your cost title says Kulsum Nessa.
Yes, lordship, her name is Kulsum lordship. Kulsuma Khatun is there in the opinion lordship, and here Kulsuma Khatun alias Kulsum Nesha lordship.
No, spelling is different. In page 77, you see Kulsuma Khatun alias Kulsum Khatun.
Kulsum Khatun.
Is your cost title correct?
Yes, lordship.
See from the cost title, page 3. Huh? page. Oh, that's why.
Kulsum Khatun.
No, because you'll find it difficult when the time of taking bail. That's why we are so cautious about the names.
Yes.
I take some time for the names because of the fact that we have seen orders where persons were not granted bail.
Lordship, in the Lordship, CAN card that is on page 19, Lordship.
No, you take a call. We are not so, we are not taking a call on that.
Yes, Lordship.
If you are satisfied with the name, we say that name.
Yes, Lordship, Kulsuma Nessa, Lordship.
Acha, okay. From say, from the cost title, huh? Page 3. So and so is apprehended, comma, she shall not be deported out of the country without order of the court. Instead, the petitioner shall cause production of a certified copy of the order. So before the Superintendent of Police, border, forfeit us, bring the order to the notice of the certified. List on so and so.
Also,
Item 12.
highly obliged.
May I please, page 44 is the impugned order, right? The finding is that petitioner could not prove the linkage.
Just a moment.
So,
Sister has not got the fact.
sorry.
Yes, page number.
Page number 44 impugned, page number 52 is the finding that petitioner could not prove the linkage.
Mr. N. Ahmed, learned counsel for the petitioner, and N. Hawks, learned counsel for the petitioner, and so for the respondents. Opinion is at page 44, dated 22/7/2025. Asked by solicitor in case number so and so, reference number so and so. By declaring the petitioner to be a foreigner post 25/3/1971. Notice returnable in 4 weeks. Stock copies in 2 days. All to the record, the following email address. Prayer for bail is opposed by the London Standing Court for the FT matters. Considering the projection date in this state petition, 10 days time to take bail or rupees 5,000 with the satisfaction of Superintendent of Police border, Borsett Happen. Please stop for 4 weeks on the seat order.
Objects.
35.
Item 13.
May I please, your Lordship, that
I think 13 কাকো দিয়া নাই নেকি? গভৰ্ণমেণ্টৰো নাই আমাৰো নাই।
মই ফাইল কৰা নাছিলো, পেজতো ফাইল কৰিছো। বেলেগে ফালে 2023 ফাইল কৰিছে।
23 ফাইল কৰিছে, 25ত আহিছে।
তাৰমানে হেৰি কৰিছে।
Lordship, extra copies may be served. 23 से फाइल करा थी।
ফাইল কৰিছে 9
এতিয়া নিশ্চয় কেনেকুৱা আহিল?
ডিৰেক্টেড মাৰা নাছিল, তাৰপিছত ফাইলটো ঘূৰাই দিছে। এতিয়া ফাইল ঘূৰাই দিছে। সেইকাৰণে মোৰ বৰত ফাইল ঘূৰাই। বহু দেৰি মই নাজানো ন বিছানা।
23 কপি এতিয়া ক'ত থাকিব?
Yes, page number
Page 62, Lordship.
62.
The Lordship, only the mother is the DW2, Lordship. Mother was examining, Lordship.
Just a moment. You have to address us on the maintainability. 2018 opinion you are challenging now.
Lordship 2018, but Lordship, the another set of advocate filed on Lordship 9 January 2023, Lordship. The letter on the case is defective and later on
To change the nomenclature, Lordship. Page 3, Respondent three, Lordship, and we do not have copies because it's supposed to be served in 2023. We could.
Just a moment.
You might even detect my end.
Where is the earlier iteration? What happened?
The lordship, the instant case was filed on 9 January 2023, lordship, another set of advocate, lordship.
This case?
Lordship,
No, it couldn't be.
and the case is defective, lordship. Not rectified the said advocate, lordship, and the later on the file was returned to the petitioner.
No, but still, when we are taking up the matter now, this is a fresh matter for us. Although the.
Change for.
Yeah, 66, 70. Total distance. Nalzam. Okay.
But still it is 5 years.
Lordship.
You have to still same thing. You have to address us on integrity.
Lordship, the highly fresh with liberty, lordship, the file on 2023, lordship.
See, but till 23, you have to tell us, why this matter was not sent, returned to the, also we don't know.
Yeah,
You have to delete it from the records.
Lordship.
We don't know. We can't accept that it was filed by another set of counsel.
Does
Your
the
name appears.
lordship, our advocate, our Ukalatna, lordship.
Yes,
Lordship,
and this is of 23.
lordship.
Then
The
what
lordship,
another set
the
of counsel?
file on lordship, the filing number
No, but you
446,
see, you are the
2020.
counsel. Why you are blaming others?
Lordship,
You are the counsel.
lordship.
Now you are saying that some other counsel filed it.
Your lordship, filed on 9th January 2023, lordship.
What did you say? Some counsel filed it.
Lordship,
You are the counsel.
lordship.
Then
I filed the, now lordship, I filed the Ukalatna, lordship. Earlier,
no, don't
another.
tell us. We'll have the registry to lodge an FIR.
Lordship.
Don't tell us that. If you have filed the Wakalatnama now, how could you have made corrections here in the Wakalatnama of 2023?
Lordship,
We'll
the
have a FIR lodged right now.
lordship, the our Ukalatna, lordship.
Wakalatnama is signed in 2023.
Lordship.
You made corrections, gave your name there, and now you are blaming others. If that is the statement, then we are lodging the FIR right now. We are passing judicial order to file a FIR immediately in course of the day.
Lordship, sorry, lordship, I will do the petition, I file it fresh, lordship.
Don't tell us those things. You take an exception to it.
I am sorry, lordship, the,
No, don't be sorry. You made corrections, you insert your name in a writ petition of 2023. And now you say some others have filed it. It will be tampering of the judicial records.
lordship, the in online, lordship, the.
We'll be very
Yes.
strict. This is, it affects the administration of justice. We'll immediately lodge an FIR.
The lordship, the I have closed the lordship, the, I photo and fresh order.
Mr. N. Ahmed, learned counsel for the petitioner, has submitted that the petition was filed in 2023 on 12. No, this is something this permits. It's. Keep that there. Filed on 9/1/2023 by some other council. And later on. A new set of council was engaged and the petition which was lying defective was rectified. And thereafter reported on 12/2025. Next, if that be so, then the insertion of name of the new set of council in the record appears to have been improperly done. According to the learning council for the petitioner, it takes leave from the court to withdraw the petition and to file it again. So, all the insurance appears for the respondents, like, if there is allowed, matter stands dismissed on withdraw, with the is paid for. Everything is tampered. The name of the list of the council, which you are required to give. There is a tampering. You have inserted a new document. Wakaratnama you have changed. The filing slip have been changed. The seal of the filing slip of the court, which is mandatory to be required to be filed, has been substituted. If that is substituted, that means the notary seal has been affixed in a backdate on the same page. How many we got is we take an exception to it. You're a regular practitioner, we condone it. You won't be doing it next time. It shouldn't be a next time.
No, sir.
We're giving you liberty to file a plate.
Yes, sir.
কি বলতে ফাইল করবো নাকি ঝামেলা করবো না লাগিয়েছিল
Item 14 for motion.
You can have
One put of one. Permission your.
Lordship, this is the petitioner younger brother was serving in Assam Police and he died in Borpeta Police Reserve on 6/10/2022. Prior to his death, Your Lordship, many FIRs and representation were filed. This is Annexer 4, kindly see page number 46. Your Lordship. These FIRs were lost before his death, Your Lordship. Then subsequently, the petitioner's younger brother dies in Borpeta Police Reserve on 6/10/2022, and the petitioner lodges an FIR, and Borpeta PS case was lodged under section 120B and 306 of IPC, Your Lordship. FIRs at FIR on page 46, Your Lordship. Yes, Your Lordship. For 989/2022. Under section 120B and 306 IPC. Lordship. This case is pending, and during the pendency of the case, Your Lordship, in this case, no arrest was made. Till that, no arrest has been made. The petitioner approaches this Honorable High Court, and Honorable High Court, by order dated.
Page 66.
Page 66, Your Lordship.
66 is earlier approached before this court. Page 66, my lord, your lordship's order was there.
Your
Earlier,
Lordship order was there, Lordship.
he approached before this court. Main person, page 67.
Order accept from the judgment of the court of judgment. Then subsequently, the petitioner again approaches the planet's judicial magistrate first class and files a complaint against the final report, Your Lordship. And the matter is pen. Exception with the court of Yes, Your Lordship. And since then, the matter is pending, Your Lordship. Page number 70, Your Lordship. 70. 70. No order has been passed till date, Your Lordship. Pending like.
Please go with that.
Parvida is the wife of the deceased. Accused.
Lordship, this is suicide case, my lord. They make main six arrest. Lordship. Lordship. Notice me. Number six, my lord, wife.
It's a
Wi-
private residence. The
Wife of the.
This is person, your lordship.
Yes.
I am the elder brother of the deceased. Notice the devoted solicitors.
Six.
Six.
Six, yeah.
Six, your lordship. Respondent number six, your Kaveri Das.
Six, wife.
Sixty-four page number. Page number 64, your lordship. Yeah, कम दिया ना ये। Assume this one.
In respect of his FIR, as it was alleged that proper investigation was not done by the IO. Full stop. Full stop. This court for the reasons assigned, close the writ petition with liberty to the petitioner to avail appropriate remedy as he may be so advised. Full stop. Thereafter, the petitioner has filed a complaint case before the Court of Judicial Magistrate First Class Borpeta, which was registered as CR 397 of the 2021. The learned, the said, the learned judicial magistrate first class, Borpeta,
Complying this, complying this, High Court
having not,
to submission.
having considered the evidence available,
On the closure report. This
found that no case under section 406 of the IPC or any other penal section law has been made out. So accordingly, the complaint case was disposed of by discharging the accused. So then we can't do anything.
Lordship, that case was filed by the deceased wife upon the petitioner, where we are acquainted.
We have submitted. Objection on the- Complying the High Court's order, we have submitted an objection of closure report on censure case. Is number 76. Of the demo population. Why also high on this? Maybe I can do. Why also high? You can, it will do, that gets closed. That gets closed.
Case is still pending. The case is still pending before learner has to see. Or better. Page 72.
Say 72 to 70.
72.
Pending was. Yes. Pending was, yes.
No,
Reminder, White also filed one case before Sorbo. And that
no,
is still
you
pending.
see, that's why he showed us page 64, we have started reading that.
Yeah.
Now, where is the, come to page 70 of your writ petition. This is a Narazi petition. Where is the order against which the Narazi petition is filed?
It's pending, your lordship. No order has been passed. in it.
Then you couldn't have filed a Narazi petition if there is no FR.
We have, by complying the lordship order, we have filed this Narazi petition against the final report. Until that, we are before your lordship because the petitioner is around 70 years. I have it-
I'm good in giving horrible examples. I'm. Without there being a closure order, you file a Narazi petition. There's no closure report.
Closure
That's what
order.
now you say.
Closure report दिया ना नहीं हमें। Closure report किसी को final report नहीं दिया।
Police closure report file করেছে। See
Closure
paragraph
report has
one.
been filed, your lordship.
Wife case also pending before CGM Borbet.
No. This, you see, we are exercising jurisdiction under what you call the division bench is taking up the matter because of against police, it's against police action. Now come to page 70. First line you write, with due respect, the informant wishes to state that the IO of the case has submitted a closure report. And we are asking you, where is the closure report? Now you say there's no closure report.
No,
If
we have
there's no
not
closure
annexed it,
report-
your lordship.
Hmm?
Closure report has been submitted, your lordship.
Where is that?
We have not annexed it, will be.
Then we can't issue process.
Only
Bring it on record.
Grant us some time will be annexed in. next year, your lordship.
No, you should have got it. You see, we have spent 10 minutes time on this, trying to understand what the matter is about. You want us to take action and you don't produce documents. You had a new set of documents. You produce documents which are of another case without filing the documents regarding that. How can you mix up two things together? Your wife's case for Sridhan, you are adding it here.
Still pending
And-
that case.
No, but this, you, Mr. What do you call, Mr. Sharma,
Lordship.
the first, in one of the paragraphs of that order, the court records that the matter has been settled with regarding to the Sridhan. So if the person has died and there is a compromise regarding Sridhan, who has done it? So the petitioner here appears to have settled that matter. And now he is pursuing this writ petition.
We'll file then rejoin the FCP, your lordship allows along with this order.
No, that's reading out your prayer. We are not allowing that. We just join it on your prayer. But this is Khalil and Council petitioner and Mr. P. Sharma and the additional senior government advocate for the respondents. Next paragraph. On the prayer made by London Council for the petitioner, the matter stands adjourned to enable him to file additional affidavit on record. Additional affidavit in the matter. Next paragraph. Just after ensuing winter vacation, as and when the additional affidavit is filed. Take a short break and come back.
For delivery of order, supply item 34.
Yes, sorry, on that day, mishap happened.
Hello. Oh. Sixteen.
60 মানে that here মানে document the expert order of the tribunal মানে
Party নাকি? 16.
your orders মানে at page 20 the expert
কার apply করেছে কি পারে? বুঝতে পারবো। লাগিবই নালাগে।
page 20 my lord
Page
2020
20.
Specific application. বিশ্বকর্মা গোর্খা কেনে বলছি।
But he appears to be a very influential person.
Well,
Appears to be a very influential person.
this one he belongs to money in fact this is covered by the division judgment of his court my lord the Indira Newar case belonging to Gorkha community
No, but whether he is there or not, he'll have to explain it to the tribunal.
my lord
And whether he is the same, you see, name of A may be A, but he can project himself to be a man with name B. So we don't know whether B is A or not. This is
Well,
only for the tribunal to
from the
decide.
record I found my lord I think it is page 16 there his mother tongue is Nepali
No, no. We are not on the, on that,
yes
but the, whether the prima facie this man belongs to, comes from the specified territory, has to be decided.
Gorkha coming from Bangladesh is my lord on image.
We don't know.
Has to.
We don't know. You see, it's possible for a man to have a different identity, claiming himself to be B.
No, they come from, all came to Assam and other places from Nepal. Starting from 18th century.
But, but this person
Yes.
was not only issued summons, he appeared, then he disappeared, then bailable warrant was issued twice.
Yes.
Even bailable warrant of arrest could not bring him.
Yes. In fact, he engaged a lawyer, my lord. He was ill and then he lost the contact with the lawyer also. He has made a statement in paragraph.
Lost contact means he did not pay fees to the lawyer.
In the village, my lord, that happens.
And I know you become very furious when you come to know that a lawyer has not been paid his fees.
Yes. In paragraph 3, he says,
What is the proof of your identity?
my lord,
What is the proof of your identity that you don't come from the specified territory?
since it is ex parte order, my lord, the proof ought to have been given by him. but that
No,
was
but here
not there.
also, what is the proof you have?
Only the inquiry report by the police, where it is said that his language is described and he speaks Assamese also.
No, that is not a proof. Your identity proof you must show, even to this court, you must show the proof of identity.
No, they came Malad about 100 years back, and now seeking the identity when they came and there is a, because we came to Assam in 1865, our forefathers. In my own case.
No, but you don't have any document.
No, and since it's part one, there is no,
No, even before us, you will have to show some document that to prove your identity.
yes, Malad, let me take time. If the man is at all contactable, even Malad, his phone number is not with me. But he belongs to my constituency, Malad, so get him down.
In this room, the best smile has come from Mr. Sharma.
Malad.
The other Mr. Sharma has given you the best
Well,
smile.
the person helps from his own.
No, that is why, that
native.
is why the best smile in this room has come from him.
Yes.
Okay.
This is not belongs to
No,
his
but you have to
nativity.
show us something,
Hello?
prove the identity.
Yes, after the Bihu, Malad.
Okay,
In the first week of February, Malad.
okay. Mr. R.P. Sharma, Ranat Senior Counsel, assisted by Mr.
Mr. Tarini Pathak.
Mr. Tarini Pathak, Ranat Counsel. Prays for some time to file an affidavit to bring on record the identity of the proof of identity of the petitioner. Mr. So and so appear for the respondents. So the matter stands adjourned today. List on when?
First week of February, Malad. First week of February.
It's from 7 January 2020.
Malad.
7 January.
January, in month of January, I have a series of cases. Last week of January or first week of
February.
February.
You're asking for February.
First week of February.
Okay. 4/2/2026.
You can have a 6 and 4 to 10. That's what I'm.
Time being item 10.
Right, please, Your Lordship. Your Lordship, the impugned order here is on page 45, Your Lordship.
2020.
Yes, Your Lordship.
Why should we issue notice? On the issue of maintainability, please address us. What is the grounds assigned?
Your Lordship, para 11, Your Lordship, page 11.
এটা মই কালি চিকেন কথা জানিয়ে নাকি দিলে জুলাই বাসে লিখতে চাইলে পার্টি যাবে অলরেডি দিলে
Your Lordship, she had exhibited five documents, Your Lordship. Exhibit A and B are the voter list of her father.
So I'm saying this explanation we can't accept too general.
Your Lordship, the order was passed in and around that COVID period, Your Lordship, when COVID was about to start, Your Lordship, from March, Your Lordship. And
No, but that ended in 22.
yes, Your Lordship. And during that period, Your Lordship, these are, Your Lordship, illiterate people, they somehow forgot and that there was a case they had to contest, Your Lordship. 2 years back, she was declared a foreigner, Your Lordship. And it is only after something happens, Your Lordship, they rushed to the court, Your Lordship.
But this is not a good explanation. It's too vague for us to accept. So saying we are not satisfied with this explanation, lead to dismissal of your application.
Your Lordship, there is an order of the Supreme Court, Your Lordship, earlier, Your Lordship, which, Your Lordship condones the limitation within that COVID period, Your Lordship.
That goes in 22,
22, Your Lordship. Your Lordship,
and that doesn't extend perpetually
Your Lordship.
beyond that.
yes, Your Lordship,
22 would not mean 22 plus 3.
Lordship.
So once the limitation period extends,
Lordship.
actually you don't get that benefit.
Lordship. Your Lordship, since she has exhibited two documents, Your Lordship, prior to 1971. And there was, the Gaubura has also appeared before the tribunal and disclosed, Your Lordship. And this relates to Your Lordship, citizenship, Your Lordship. Your Lordship may peruse the records once, Your Lordship.
But 2020 opinion, we are not producing the records on merit. We'll have to examine it on the question of delay and latches.
The Gaubura went on to say that he knows the father of the petitioner, Your Lordship.
When he was 12 years old.
Yes, Your Lordship. And she is a lady of 65 years, Your Lordship. She also voted in the year 1997 from the same constituency, Your Lordship.
Where is your first voters list?
Your Lordship, the voter list of 1997, Your Lordship. That Your Lordship will find page 21, page 21. My name appears on serial number 228.
Which pages are these voters list?
Sorry, Your Lordship.
Which pages are those voters list?
66 voter lists. Lordship.
No, the
Ni-
voters list on which you are relying.
1997, Your Lordship, page 21.
Only one voter list.
Yes, Lordship. She exhibited only one voter list before the tribunal, Your Lordship. Page 21, Your Lordship. Your Lordship, I'll leave it to your Lordship, so Your Lordship, but only thing is that Your Lordship, I'm praying for following the records because Your Lordship, before referring this matter to the tribunal, Your Lordship, certain Your Lordship, procedural norms are required to be followed as mandated by law, Your Lordship, whether that has been followed or not. And even in the order, Your Lordship, her father's name has been written as daughter of late Amjad Ali. So, Your Lordship, that Amjad Ali's name appears before the cut-off date, Your Lordship. These are the only two submissions, Your Lordship, that I'm putting forward, Your Lordship. Lordship. Pleasure.
Lordship, I would like to cite just one judgment on delay, Lordship. And the latest judgment by the Supreme Court, Lordship, it is Shivamma Lordship, Shivamma dead by versus Karnataka Housing Board by Justice Pardiwala and G.N. Mahadevan. Lordship. Huh? Yeah. Lordship, here the Supreme Court has held that when the petitioner approaches the court after long unexplained delays, yes, Lordship. Shiva Amma Lordship, SHIVAAMMA, Shiva Amma in bracket dead. Yes, Lordship. Versus Karnataka Housing Board. Authored by Justice Pardiwala and Mahadevan, Lordship. Hmm? Lordship, it is not yet reported, but it is civil number is there, Lordship. Civil appeal number is 11794 of 2025. I can share it with the court master, Lordship. It's a 170-page judgment. Lordship has found it.
And that's just what happened.
Inordinate delay has to be explained each day.
That has to be explained.
Each day delay has to be explained. Each day. Yes.
One petition has to be.
The requirement to explain the entire period of delay is not expressed. Explains.
The Supreme Court was only dealing with section 5 of the Limitation Act. It
Yes,
was-
Lordship.
It did not deal with the issue of delay in latches or the issue of limitation in a writ petition. In a writ petition, limitation doesn't apply. So the Supreme Court ought not to be, would not have discussed in the context of the civil, in the context of the writ petition. Because there is another judgment of Supreme Court of India where after 40 years, an amendment of plaint was allowed under unusual circumstances. After 2 rounds of proceedings before the Supreme Court of India,
Hmm.
after 40 years, prayer for amendment was allowed in a suit. So it would depend on the litigation, but here it is only sufficient cause. for good and sufficient cause. That sufficient cause is being interpreted.
Lordship, there are other judgments also. where
In
there's-
this, if you have this in the last paragraph of this order, you'll find that this is required to be circulated to all the high courts. So
Yeah.
we have, it was circulated and we have it.
So Lordship will get it otherwise also.
Hmm?
Lordship will get it otherwise also, Lordship.
No, we have it. I have it in my table. Last.
Yes, yes,
paragraph.
Lordship.
This order be circulated to all the high courts. Registrar generals of all high courts will be placed before the. Okay.
Supplementary item 35 for motion.
Wait, please, your lordship. Lordship, the petitioner, she was earlier declared as a foreigner, lordship. Thereafter, she approached before this honorable court, and this honorable court had order dated 5/8/25, remanded back the matter. Thereafter, she again appeared before the tribunal, and the tribunal again declared her as a foreigner, and the impugn order is at page 101, lordship.
The order. It to court as well.
101, no problem. For the declaration.
This, as that's learned also for the respondents. Page 104, dated 31/10/2025. And the other part in the order is at page 101. Filed by so-and-so in FT case number so-and-so. SP Border Nagaon case number so-and-so, they were declaring the petition to the Pardon of Court 25/1978. Notice returnable in 4 weeks. For the records, the following email address. Here for bail is opposed by the learned standing counsel for the FT matters. In view of the protection, 10 days time to take bail of rupees 5,000 if is satisfaction of Superintendent of Police Border,
Lordship, SPB Hujai.
हो जाए. इसका तो बहुत सही है.
Obliged, lordship.
36
Made pages of. Lordship may kindly find the order at page 36, ex parte order of. Notice was served by hanging in the compound of Gao Panchat office, Lordship. Page 36 is the input order.
You become an expert in Gaon Panchayat.
Lordship.
Notice.
Lord-
Same place,
Same place, Lordship.
same village.
Yes, Lordship.
The earlier order.
Impugned order, page 36, Lordship.
No, the order which we passed earlier, where is that?
Oh, Lordship, that order is.
This is your third case from the same Panchayat. Okay.
Service report, page 33, Lordship. Case number 2 is complete.
Problem.
Maybe 5 minutes delayed in assembling again.
Supplementary item 37 for motion.
Lordship, my lord, this input order is 147, annex are 31.
Hasi.
Page number 147, annex are 31. My lord. My lord, the paragraph 34, page 23.
This is not an acceptable reason.
My lord, the actually, my lord, actually, he is the my lord as per record, my lord. His grandfather, NRC 66, 70.
No, but he should have come.
My
on
lord,
time.
his father, my lord, is a poor illiterate person, my lord. Earlier, my lord, approved this honorable court expiry order. Subsequently, he, my lord, appeared, my lord. So, my lord, my humble submission, maybe, my lord, call for the record, my lord. My lord, actually, he is the, my lord, Indian, my lord. So, opportunity may be given for the, my lord, poor illiterate person to, my lord. One opportunity may be given for call for the record and actually, my lord, this, my actually fact I will state it in this petition, my lord. And is no, my lord, aware about this law, my lord, and approaching, my lord. So, my humble submission may be considered for record and pass the order, my lord.
Yes, for the state, what do you have to say?
Project, first of all, I have objection in regards to the delay and lectures project. As the impugn opinion hearing, that was passed in the month of December 2019. And as per the statesman and government made in paragraph 34 of the petition, it is stated that he went to Kerala in the month of January 2020. That is after passing of the impugn opinion. So he had the knowledge of that impugn opinion. Thereafter, in the month of January 2020, he went to Kerala. Thereafter, he returned in this year, October 2025. But the certified copy says that it was obtained in the month of June. As page 147. Thereafter, he has approached this marriage court. Deviation of statesman are here from record, and delay and lectures is also the other. On the ground of delay and lectures, this rectification will be postponed.
We will examine the records and pass over. I forgot your name.
And but no, when but
In Patrick, I'm sorry. Okay, we'll examine and pass over this.
My Trinity Manu, call for the record.
We'll take a note of your submission from this.
RT8.
This is Roshan. Roshan, we kindly find the impugned order at page 51.
Page
51, Roshan, 51.
51. Understood. Am I still on the petitioner? And transfer for the respondents. Page 51, opinion dated 15/7/2025, passed by so-and-so in case number so-and-so, I am dated reference number so. They were declaring the petitioner to be a partner of the contract medical services. Notice dated on 4 weeks, 6 copies. Copy the records to the following email address of the Leonard partner. Therefore, bail is opposed by the one standing up for the matters. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border.
Order Bongaigaul.
Okay. This stuff of this. Deeply obliged.
Supplementary item 39 for motion.
With pleasure, Lordship. This is a contested case, Your Lordship. Impugn order is at page number 84, Your Lordship, and it's 18.
This is K. Begum. Petitioner. Page 84, opinion dated 15/9/2025. Bail to the satisfaction of Superintendent of Police Border, Nagaon.
No,
4 weeks.
Upgraded item 40 for admission.
So. This case, my lord, supplementary charge sheet already filed.
Oh, supplementary charge sheet file.
Filed.
But the dead body is never found.
Lordship,
Dead body is not found.
not found. Earlier, my lord, this was directed to produce case diary. Justice, Honorable Justice Committee and member. And I have produced case diary. After case diary, my lord, the police returned the case diary, police filed supplementary charge sheet, and it mentioned clearly that final charge sheet will be filed after. It clearly mentioned.
None appears on file for the petitioner. The Mr. P. Sharma, an additional senior government advocate, has produced the status report by the inspector, officer in charge of Sonapur Police Station, City Guwahati. Status report dated 8/12/2025 by inspector, officer in charge, principal, stating inter alia, stating that
May I please your lordship? Your lordship, the conducting
passing orders. Your name?
Passing order. Naam pe to.
Myself, Anil Lashkar, on behalf of Anish Bodavaya.
Spell your name.
N-A-N-H-N-A Lashkar.
N-A. Laskar.
Lashkar.
The- Take your breath. Take your breath. Don't be excited.
Not me, sir. You should be.
Sit down. Take your breath.
No, my status.
The- Investigating officer had submitted a charge sheet, right? Sonapur PS charge sheet number 167/2025, dated 5/12/2025, against 4 accused persons. Namely, Mizanur MIJANUR, Mizanur Rahman, Sorvesh SHORBESH, Sorvesh Ali, Amir Ali AMIR ALI, and Alauddin Ali ALAUDDIN Ali. Under section 61, within bracket 2/142/103, within bracket 1, bracket close BNS. It has further been stated that secret sources have been kept engaged to recover the dead body of the victim. And on completion of the investigation, a final charge sheet would be submitted. Next one. In view of this status of investigation, and taking note of the fact that a supplementary charge sheet has been filed, the court is inclined to adjourn the matter, awaiting updated status of investigation. Next paragraph. The The knowledge senior committee, additional senior committee, which will communicate copy of the order before to the concerned authorities. Send the updated status report of investigation. This problem. Second of February. 2026. They have filed supplementary charge sheet against court. And they are taking steps to recover the dead body. Final charge sheet will be submitted only after that. We are adjourning the matter.
Much obliged, Your Lordship.
Upgraded item 41 for orders.
No.
But in this case, we were supposed to file an additional affidavit, we have filed it day before yesterday. Is that or not? Yes. Yes, sir.
By R4,
Yes, respondent number 4.
then it's there.
No, earlier there was, my lord, day before yesterday also we have filed an affidavit. Both the persons, my lord, they have been handed.
My lord, these all put, my lord, on 1st of September, pass an order, my lord, so file specific affidavit.
It has come.
Lost.
16
Basic-
December, it has been filed.
But they have not, my lord, clarified any point, which was
No, we have not even gone
lost.
into it, just a moment.
lost. একেবারে বুঝলাম order.
Yes.
My lord. So, my lord, that is there, my lord, they examined it initially, my lord, because my lord, order, my lord, opinion was an expert opinion, my lord. Opinion was an yes. Yes. Because the other aspects, my lord, if you'll also clearly see, page 20, my lord, para 3. Page 3, para 3, my lord. Fatima Khatun, who was a resident of Uttar, same area, and my lord, it was more, yes. Yes, ma'am. Yes.
Even fine. But the person elected from country. Now, even fine.
Yes.
Still, with eight, six. We understand where we think. Still, in the age of 60. Second, the vendor is incomplete. Technical 10%. Yeah, I think that.
They were sent on immediately on that day itself, my lord, when they were decayed after. That was examined, my lord. After examination only that has been returned. Yeah. 26, my lord. Definitely, there was some delay on it, my lord. My lord, I pray apology for this, my lord, because I
6th of January. As I represented, the additional affidavit by the respondent has been filed. Sixth of that, then 8. What says it? Additional affidavit or respondent has been filed. In view of the nature of grievance raised in the present petition, the lead petition is admitted for hearing by issuing rule returnable forthwith without requiring any further steps to be taken. List the matter for hearing on 8 January 2026. We are not saying anything. Just fix it for hearing. I'm just saying yes, not saying no.
Upgraded item 42 for orders.
দুটা আপিল আছিলে তোৰ পৰা আনিছ নেকি? পুৰণাটো আনা নাই। My lord, the delay, my lord, we have pleaded, my lord, regarding the main ground we have taken as a financial constraint. And my lord, secondly, my lord, as already there is an appeal is pending arising out of this common order, my lord. So in the course of the in the development, my lord, during the course of the hearing of the first appeal, my lord, this necessity of, my lord,
challenging this part of the order, my lord, has been come up. So, my lord, that therefore there is a delay, my lord, admittedly, my lord. Now, my lord, the issue is in such a situation, my lord, if we do not put into challenge the appointment of these private respondents, my lord, then though we have been reinstated by of the impugn order, my lord, by the Honorable Learned Single Judge, but, my lord, we cannot be accommodated because our position has already been, my lord, filled up by these private respondents, my lord. Now, on the one hand, my lord, the Learned Single Judge has held that the selection and appointment, the manner in which this private respondent had been inducted was, my lord, not in accordance with law, my lord. My lord. My lord, on Monday, my lord, my lordship has clubbed this writ appeal along with the first appeal, my lord, to examine that, my lord, whether in the cost title, my lord, that was what I remembered, my lord. Because my lords, no, my lordship is. No, my lord, many matters every day, my lord. It's not so easy also, my lord. So, my lord, my lordship has also put a question to me, my lord, that whether it is barred by the constructive res judicata, because, my lord, we have put into challenge the same order in two different appeals, my lord. Well, yes, my lord. Arising out of the same order, my lord. My lord, my respectful submission to the query before put by my lordship, my lord, is that, my lord, altogether 4 numbers of writ petitions were clubbed together and heard together by the Learned Single Judge, my lord. And in those writ petitions, my lord, the prayer was, my lord, different and distinct, my lord. Was the cause of action was different. Now, my lord, the writ petition by which, my lord, we put into challenge the advertisement as well as the appointment of this private respondent, my lord, has been taken care of, my lord, by the Learned Single Judge. I would like to draw my lordship's attention, my lord, to the last paragraph of the page number 426 of the fresh appeal, my lord, the new appeal, my lord, which has not yet been numbered, wherein in para 38, my lord, it had been dealt with, my lord. My lord, my lord. Yes, my lord, the writ petition of WPC, my lord, 6242, my lord. Huh? My lord can find it at from starts at page 178, my lord. My lord. And the prayer part, my lord, may be pleased to find at page 191, my lord. 191, my lord, by setting aside and quashing the impugn order dated. Appointment appointment 4760 232 no 296.
My lord. My lord. Yes, yes, my lord. Page 191, my lord. Thirteen twelve 2012. Yes, my lord, it is session lecture 1312. Annexure 7, my lord, may be pleased to find. Huh? Yes, yes, my lord, my lord, may be pleased to find is at page, my lord, 200 and 231, my lord. The original copy in view of the order. Type copy is at page 229, my lord. It will come on WP. Page number. Are you to finding the copy? In order. It's coming up. It's coming given. Nine. Wait. Last of this. However, it is provincialization of the services within the respondent shall be subject to the decision of the. My lord. No, my lord, the private respondents were appointed by my lord. This order, my lord, what has happened, my lord? Initially, the director of higher education, my lord, has passed an order by which the decision of the my lord, governing body of the college was, my lord, was in our favor, my lord, that it was not done in accordance with the law. Then that order has been, my lord, captain of abeyance, my lord. And this is challenged in this writ petition, my lord, and the appointment of the private respondents, my lord, had been put into challenge in WPC, my lord, 6728. My lordship may be pleased to find is at page 51, the prayer part of that petition, my lord. Page number 51 of the appeal memo, my lord. Page starts at, my lord, 36. 6728 of 2014, my lord. The prayer specifically we have made, my lord, to cause the advertisement and the appointment of this private respondents. Now that has been taken care of, my lord, by the learned single judge in the last paragraph at page 426, my lord. That though on the one hand, my lord, their advertisement and this appointment has been held to be, my lord, not in accordance with law, but those appointments were not interfered with, my lord.
Within the, when we can see the hospital as well as prayer of the recovery and the prayer of the earlier recovery. Because the prayer also needed 32 in the memo of appeal in the new. But the relief sought for in the appeal to modify, set aside the judgment and order dated 18/8/2021, passed by the Venice Single Judge in WPC number so-and-so along with other connected officials. In so-and-so, to the extent that the same does not provide any consequences of the appointment of the respondent number 48 and directed the appellants to appoint the Manor Educational Tribunal constituted under the provision of the Assam Educational Provincialist of Services of Research and Reorganization of Educational Institution Act 2017 to raise the claim of the petitioner for provincialization of the services under the law, to set aside and quash the orders of appointments of the respondent number 48, to provincialize the services of the appellants under the provision of the Assam Education so-and-so amended so-and-so by setting aside and quash the appointment services of the respondent number 48 to provide consequential benefits of provincialization as per the Assam Education so-and-so as amended so-and-so. Not to provide any benefit provincial of service of the respondent number 5. Pass as order. Well, have the earlier deputy to take a bit. And then 247, W8 247, the prayer.
Page.
Just page 58. Oh, sorry.
32 page.
Just 30. The 1-1 to modify and set aside the judgment and order dated so-and-so passed by the London Single Judge in so-and-so along with other connected disposition so-and-so. No, so 32. Page 32. It's rare.
Already read.
As it is said, prayer. On page 32. 32 of the earlier.
No, same page
Copy
number.
of the earlier written. Not there.
Economy.
Of the memo. my lord. Yes. 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 Yes.
Please tell us, there are 4 proceedings, let us
Three.
forget 4, let us say 2 writ petitions are decided together. by a common order. Technically, 2 appeals are required to be filed.
Yes.
Here, there's an omission to file the appeal in one writ petition. So even if there is a delay of 670 days, what would be wrong to entertain the application because of the fact that intra-court appeal must be related to a particular writ petition? So technically, the filing of the present writ appeal, we don't find anything wrong legally, except for the delay.
Malata, in that case, my humble submission with my lordship, the earlier writ petition pleadings as well as prayer, writ appeal and the present writ, pleadings and prayer is checked. So it is clearly hit by the prospective writ petition. And number one, the delay,
No.
delay portion is
No.
there. Correct?
Let us say in these 2 writ petitions, the prayer is only one. Set aside the appointment of A, in the second it set aside the appointment of B. Correct? A common appeal is filed. In one appeal, A is the party. B was not a party, so the second appeal, the second writ appeal file, B is also made a party. So the prayer is otherwise against both of them. In this case, there are 4 respondents. The appointment of the respondent number 4 is in challenge in page 51. I believe in all other 3 writ petitions, the challenge is to the appointment of only these 4 persons. Definitely then in all the appeal and all the writ petitions, the prayer would be same.
Then, Malata, if the appeal has been filed.
Can you give us an undertaking that you will, today will record your undertaking, that you will not take the plea of non-filing of the second appeal in this 6 to 42, when the other petitions are taken up for hearing? If the prayer is same, you are not prejudiced.
No, but that's not present, but my humble submission with my lordship.
No, you see, once you start, no, Mr. Islam, once you start with no, that means there is something there. So technicality will not come in the way of the court to condone the delay, because it gives us a substantive advantage to the respondent merely because 2 appeals have not been filed, and under the High Court rules, if it's a common order, common judgment, then technically 4 appeals are required to be filed or leave be taken to file a common appeal. Yes, you wanted to say something? We have no difficulty, but can we record your statement to that effect? Because that would be the ground. We accept your ground and we dismiss this writ appeal on the ground that the delay is not condoned, because you have no objection if this can be agitated in the other writ appeal.
Yes. And the grounds, Malata, which has been given.
No, grounds will come later on. You see, we are now examining only 6 months, 7 days delay.
Yes.
Last time when the court query was there, we could not follow this submission of Mr. Bhuyan. Successive writ can be filed, successive appeal can be filed or not, but if there are 4 appeals, 4 writ petitions tagged together, taken up for a same hearing, unless you show that.
In respect of the delay is concerned, my lord,
Yes.
the explanation of delay is not properly done. Well, can you see, the only explanation their financial term. Since they have filed one after another writ petition also filed.
Mr.
So-
Islam, since the day I am sitting in this bench too, this is the only thing I am hearing. Financial difficulty, please condone the delay. There is 8 years delay in filing of the challenging the opinion. There is 12, 15 years delay on challenging the opinion. Poor fellow. This is the only thing I've been hearing. You must, in fact, privately ask Mr. Yeah.
Sometimes submission was one official still going on. The out of the same prayer, same another bit. Because with that effect, they have to make some specific prayer. That means that in respect of that prayer, they have filed it.
On the ground, there is possibility. There is a big flow. It's not like it's not a fire. Where once a fire is filed, second the fire will only be a statement. It's unrestricted like that. There will be a statement in the one statement.
Yes.
That is the law. You can ask for the teacher.
Delay part concern matter, but only have Mr. Lordship that calculation which has been made is not satisfactory. And in respect of the admission of the readability concern that I will, yes, later on I will matter.
Read petitions, my lord. My lord. Other my lord may be pleased to find is at page. Let's read this up. Next page starts at page 178, my lord. That is W 6242 and the prayer is, my lord, page 191, my lord. Next.
Here also the first prayer is to set aside and quash impugn order dated 13/12.
My lord. But my lord,
Then third writ petition,
third is, my lord, page 250. No? Prayer is at 250, my lord. Writ petition starts at page 232, my lord, and prayer starts at page 250, my lord. 11/2/2013, no? 13/12/2012. Prayers are different. Last week, number. 2009.
তিনটা।
So this is against termination
My lord.
and other petition,
My lord, my lord, only three petitions, my
only
lord.
three, okay.
Yes, my lord.
You have the copy of memo appeal of the other two the appeals?
Yeah.
Pass it on.
My lord can take another one is here, my lord. For my lordships.
Same appeal.
Same. The first one,
47.
first one.
That's a different
First
copy.
This okay, we
It's
can.
written,
take-
Mile.
same copy.
Right. Same as, no? Jacqueline. Telephone. Hmm?
Same.
ये पुनः बनाए थे अभी तो अरे बनाए बोले कॉपी करे पेस्ट कर रिप्लाई को तो कथा लिखा नहीं है रिप्लाई को तो कथा नहीं ओके अगले सुना है ये तो प्रॉब्लम है बहुत देखो मैं बना दिलो हम दिल में लोग माथा लगाना
Wait.
Having considered everything, But today Ms. Verma had reminded us of the judgment of the Supreme Court of India
Mal.
in this Shivama versus Karnataka Housing Board.
Mal.
In this matter, the Supreme Court has observed, because the SCC and this, the document which I have may vary. Here, in paragraph 261 and 262,
Mal.
the laxity and lethargy in the challenge has been deprecated. You have to overcome this. 617 days.
Yes, sir.
The fact which is troubling you is correct, because even though both the writ appeal have the same prayer,
Mal.
but the prayer number 2 in your earlier writ appeal 247
Mal.
shall not be looked into because of the corresponding absence of prayer in the writ petition.
Mal.
So because of that, prayer, this prayer 2 can only be substantiated if the appeal is filed in this first writ petition, that is
624.
6242.
Mal.
We understand your anxiety, but now since Ms. Verma has reminded us of this Shivama, you have to overcome it. Otherwise, that way, we understand now after you have explained it to us,
Mal.
but then Shivama comes in your way again.
Lethargic approach, my lord. My lord, sometime these people are, my lord.
To take a call, we take it up in the opening.
My lord.
Fifth.
Lord, can it be after 10th, my lord?
After 10.
My lord.
After 10th, then we go to 19th of
My
January.
lord. My lord.
Because outside the represented, the prayer made by the
Government.
applicant,
My lord.
this term,
My lord.
17 and 19, 1, 2026.
Oblige, my lord.
Next time, please remind us of the sequence.
My lord.
This prayer and all these three, please connect
Yes, yes. my
next
lord.
day so that we don't have to turn pages.
No, my lord, I will try to recall my lord. Oblige.
Item 15 for admission.
there any voters list where your father and all your brothers are together?
Page 42, my lord.
42.
42. Other family members are also there. This is my lord voter list of. Gosh. Hmm? Mustafa.
No, all your sons are not there together. You are only with Abdul Malik and Tajuddin. Two of them.
Abbas. And along with other brothers, my lord, 1966 Bhuta list, my lord. List.
No, not brothers. Your fathers and your siblings
No, my lord.
together. That is not
Please.
there. You did not vote because in the first voters list your name came as D.
Lordship.
So how are you connecting yourself to your projected father apart from the evidence of this DW2?
DW2, my lord, he's the father, my lord.
Except for that,
So-
how do you, that is oral evidence. So how
Sorry.
do you connect yourself? Any document?
School certificate proof for Naito. School certificate proof for Naito.
You know, in your case, what has happened? Please come to page number 53. 53 in your
Cross, my lord.
cross examination, you say your father's name is Akes Ali. And then your father came at page 58. He also says Akes Ali. But then we found somewhere that there's a discrepancy of name.
Akas and Akes.
Yes. So in the cross examination, your father and you differs with only one name.
And tribunal has not discussed anything my lord, regarding father, my lord. And other document has also not been discussed. my
Where
lord.
is the opinion?
Opinion, my lord, is 60, my lord. And regarding
DW2 not discussed.
page 60, my lord. Page 60, my lord, exhibit A, then father's cross has only this much, my lord. There is nothing.
No, your father did not prove anything, but his evidence not discussed.
Lost.
DW1.
Page 63, my lord. Father of the procedure also cross-examined as DW2. In his cross-examination, he deposed that he has 4 sons, but he does not remember when they cast their vote. In the evidence of DW2, has not disclosed why his name not appeared in between 1997 to 16.
2016, yes.
Only
So that there's a discrepancy because your father did not say anything more. The evidence of your father, we have shown it to you. That is it. The cross-examination at page 58.
yeah. 58, my lord. In seat, my lord, he has enclosed
But that
everything,
is
my
only
lord.
oral evidence.
And here, my lord, the second party, Akbar Ali is my son. In page 58, my lord. I have four sons, so and so Akbar. না না করবেন কি কনসেশন থাকলে বের করতে গেলে
It's the DW2 has come. He projects himself as the father. Even the oral evidence could have been discarded by the tribunal. It does not say anything about the evidence of DW2. It does not reject any of the evidence, but there is no discussion. You see, the tribunal could have, if it wants, it could have said that the evidence is not acceptable because of the fact that it's an oral evidence. Identity of the persons are not established.
ডিসকাশন নাই
You see, the evidence is not discarded. Not discarded, then accepted. But we take up after opening this. Too much matters for these 2 days to be a complete problem. 6, 7. Next time we examine the record and tell us. The only point is that DW2
Streets are there, some.
Both sides are represented. This is the matter. Which present problem, with a positive time, the matter could not be heard today. Less strong. Expecting this first week. What?
Ninth of January.
Publishment.
Item 17.
Lordship. Lordship, Mr. A. Mateen, due to personal inconvenience, he left the court. Okay. Okay.
Both sides are represented. On the prayer matter, Mr. James Suleiman, possible to. This on 19 January.
Of Lordship.
Eighteen.
Yeah, clear the lordships. My lord, page 15 and 16 is my NRC voter details. Page 17 and 18, the voter list of 1966 of my father. And 1970, 1920 is voter list 1970 of my father. My lord, kindly see page 5, para 3. That the petitioner begs to state that she was born at Morabat village, Senglitia, PS Saragat district, Barbata, due to salvation, her father shifted along with his family to village Kaharpara, PS and district Barbata. The petitioner got married to Alimuddin, son of Nazar Sheikh of village Satipur, PS Taligaon, district Sidang on 2/3/1993 as regard to her linkage to her father, and also of her marriage, a linkage certificate 29/5/2023 was also issued by the secretary 25 Doumari Pathargaon Panchayat district Barbata. My lords, the copy of the linkage certificate dated 10/12/23, page annex 4, page 23/24 and 29/5/2015, page 25 and 27. Let the petitioner state that she, along with her uterine brother, Samaj Ali, and inherited land from their village at Malibara, covered by Dang number 133, Patta number 98, under Sengar Revenue Circle, district Barpata. In this respect, the land document, Exhibit C, has been issued by the circle officer, Sengar Revenue Circle, as a land possession certificate dated 27/3/2008. The tension copy as well as certificate of the land document dated 12/2018 and are annexed very. My annex 6 and 7, page 28/32, 28/32, 33/34, my lord. That petition stated that after her marriage, her name appeared in the voter list 1997, Exhibit E, and 2008 under Sidley LLC along with her husband. The copies of voter list of 1997 and 2000 are annexed. It is, my lord, on page 35 and 36 and 37-38, my lord. That the petitioner stated that after the year 2008, the petitioner along with her husband shifted to nearby village East Satipur, P.S. Dhalingaon district, Sidang, and her name appeared in the voter list under the said village. She has also been issued with the voter ID card and PAN card, my lord. My lord, my voter list copy 2015, 2018 voter ID card and PAN card, my lord. Annex 10, 11, 12, and 13, my lord. Page 39 to 40, from 41 to 42, 43, 44, my lord. That the petitioner best stated that her uterine brother, Shamesh Ali, DW2, has been declared as a citizen of India. Her judgment and order dated 6/4/2016 passed by the Learned Finance Tribunal number 1, Barpata, in FT case now, Senso, wherein they exhibited the voter list. So, her father land revenue payment received from land C amongst others, which has been exhibited before the Learned Finance Tribunal. The copy of the judgment and order also annexed minus 14, page 45 and 45 to 46, my lord. My lord, after for reference, I appeared before this before the FT court, my lord. I filed written statement, evidence of DW1 and DW2. DW2, my brother, Shamesh Ali. I met at NS 47, 50, 51, 58, 49. My lord, the finance tribunal by book order dated so adopted the petitioner as not trustworthy. My lord, my documents are not trustworthy. The learned foreign tribunal does not appreciate my report, my lord. As such, the judgment of the FT court, Annex 18, page 63 to 60 is vitiated, my lord, as per law, my lord. My lord, what is the ground? I don't understand. Why it is not trustworthy, my lord? No ground, my lord. My land, I have also furnished a land document and land certificate, 66 voter list. That debate, my lord, page 9, that 10, the petition based to submit that the Learned Finance Tribunal rejected the certificate copies of voter list of 1966 and 96 Exhibit A, and be on the flimsy ground that the petitioner was not able to say her parents were voters of his LSC, the name of LSC, house long, CL long, in the cross examination, which is due to her illiteracy and ignorance. Although the same were clearly mentioned in the evidence prepared by the council and submitted by her along with exhibit. The Learned Finance were rejected the certificate copy of the land document Exhibit C on the LS ground that the land document was in the name of Mansur Sheikh, not Mansur Ali. Although both the same are one and same person, and soon as Mansur's son of Thomas, who is the grandfather of the petitioner, and it is evident from the voter list at 1966 and 1970, Exhibit A and B. The land possession certificate is a D issued by the circle officer Senga, revenue circle of the petition, letter of Mansur was not taken into consideration on
Take it
the
up this
LS ground
tomorrow
that
as a parted matter because I have to rise at 10.
my lord, the petitioner is not arrested
No, tomorrow
on
we'll
due
take
reason.
We are taking it up tomorrow, parted matter. Heard Mr. A last time counsel for the petitioner, his submissions remains inconclusive. All the respondents are present. Next, but I finished this is parted matter on tomorrow 18. Tomorrow we are taking up as parted matter.
Tomorrow.
Single bench item 1 for orders. IA Civil 313/25 in WPC 519/25 disposed of.
Any objection to the prayer, Ms. Sanju and Mr. Chandran?
No, Lordship, no.
No. We allow this, Ms. Sanju?
Yes, your lordship, no objections.
Okay. Your name for the petitioner, I did not get it.
T Tatak, Your Honor.
P Tatak.
T Tatak.
Yeah, I'm sorry, I couldn't make out from here. Okay. Any grievance that without hearing you, we are passing orders?
Your Honor, no, there is only humble submission that the name of the petitioner society may be corrected as Jovin Welfare Society. As I have annexed the registration certificate as Annexure A.
Okay.
Your Honor, please
Uh,
say page
so
number
the
13.
Learned counsel for the applicant. Also heard. Mr. A. Chandran, learned additional
Senior government advocate.
senior government advocate
Lordship.
for respondent number
1, 3,
1
4,
and 3.
1, 3, 4, 5.
Oh, 1, 3, 4, 5. And Ms. Ananju, learned standing counsel for respondent number 2 and
6.
6.
Lordship.
By way of this interlocutory application, it is projected that the name of the applicant society is Jovin Welfare Society, which was inadvertently mentioned as all Jovin Welfare Society in the connected writ petition, which were disposed of by an order dated 11/11/2025, passed in WPC 519 of 2025. In this regard, the learned counsel for the petitioner relies on the certificate of registration of the applicant society under the Societies Registration Act from 1860 as modified. Next paragraph. The having heard the learned additional senior government advocate and the learned standing counsel for the election commissioner, a prayer made in this application stands allowed as it will not prejudice any of the parties. Next paragraph. The petitioner, the applicant shall file amended cost title of WBC 519 of 2025 before the registry at Itanagar Permanent Bench. Full stop. On receipt of the same, the CIS system would be updated. Full stop. Thereafter, the applicant society shall. Mr. Tatak, you can return the certified copy
Lordship,
because you have to surrender the certified copy
Lordship,
of the earlier order dated 11/11/25. Can you do it?
Lordship.
Okay. Stop. Thereupon, the learned counsel for the applicant shall return the certified copy of the unamended order passed on 11/11/2025. Thereupon, the registry shall issue a fresh certified copy of. Actually, you don't need to say that. Don't return. Okay, let it remain.
Lordship.
Thereupon, the name of the applicant society, applicant / petitioner society, all Jovin Welfare Society, appearing in WPC 519 of 2025, shall be read as Jovin Welfare Society for all intents and purposes. Next paragraph. This order shall be read together with the order dated 11/11/2025 passed by this court in WPC 5929 of 2025. Okay,
Lordship. Lordship.
this interlocutory application stands disposed of.
Deeply obliged.
Obliged. Obliged.
Deeply obliged.